to join. I'm going to give folks a couple more minutes to join.
Hunter, can you just let me know when you're ready to start so I can press record?
Yes, I would say that you should start recording now.
Okay.
Okay.
Yep, sounds good.
All right. So just wanted to let everyone know, all of the attendees know that if you want to turn on the closed captions, you can hit CC on your screen and you should be able to see that. Okay. All right, well, now that it's a couple minutes after 3, I think we can go ahead and get started. So welcome everyone. My name is Hunter Iannucci. I use they, them pronouns. I'm a legal fellow at the National Women's Law Center, and I focus primarily on student survivors of sexual harassment and assault, as well as issues impacting LGBTQI+ students. And I will be moderating today's panel, defending queer and trans students, hot topics in education, civil rights law. So before we get started, I wanted to take a minute to thank everyone for showing up today to learn more about how we can best support our LGBTQI+ clients. I think it's really important to note that we as legal professionals, seeking to understand how we can validate a person's lived experiences with discrimination is so important, because that is truly how queer and trans people experience discrimination, as people whose identities shape their lived experiences first. I also want to take a minute to note how important it is for us to be showing up for the LGBTQI+ community at this moment in time. LGBTQI people, and especially students, are facing vicious attacks by state lawmakers and extremist hate groups. We've seen well over 300 intrusive and discriminatory bills introduced just in 2022 that run the gamut from banning trans, non-binary, and intersex students from school sports to bills that censor classroom discussion of LGBTQI+ students' very existence. We've also seen extremist groups direct hateful rhetoric and violent threats towards LGBTQI youth and the adults that try to protect them. And to make matters worse, we've seen recent opinions from the Supreme Court that privilege specific viewpoints, causing LGBTQI+ people to fear for the erosion of other precedent protecting their rights. These people unjustly believe that LGBTQI people can and should be walled off from accessing protections under civil rights laws. And they seek to destroy for LGBTQI+ students the promise guaranteed by federal civil rights statutes, like Title IX, to protect all students' abilities to access the benefits of an education free from sex discrimination. So it is with this very terrifying moment for civil rights laws in our country that I thank you again for taking the time to show up here today. It means so much, at least to me personally, to see so many advocates in one space, showing up to push back against this hate and work towards a future wherein LGBTQI+ people not only don't have to be afraid to be who they are, but are celebrated for it. So in the spirit of working towards that future, I will now turn towards introducing today's panelists. So first we have Ming Chu, Deputy Director of the Women's Rights Project, and Daniel Mock, Director of Freedom of Religion and Belief at the ACLU, and they will be leading part 1's discussion, Legal Protections for LGBTQI+ students. And then finally, we have Liz Pinolini, staff attorney at Whitman Walker Health Legal Services. They will be leading the discussion in part 2, best practices for representing LGBTQI+ clients. In terms of the schedule, we will be ending around 4 p.m. with about 15 minutes reserved for questions and answers for our panelists. And if folks don't have any other further questions, I can now turn it over to Ming to begin part 1.
Thanks very much, Hunter, and thanks to you and Anna and the Law Center for putting together this very important discussion. So I'm going to begin by talking about some of the positive developments and setbacks we've seen in advancing protections for LGBTQI students. On the victory side, I'm going to talk about the new Title IX NPRM Notice of Proposed Rulemaking that the Office of Civil Rights of the Department of Education just issued last month, confirming that discrimination on the basis of sexual orientation and gender identity is sex-based discrimination and enhancing obligations for educational institutions in responding to discrimination and harassment. So this NPRM has a lot of changes that advocates have wanted to see, and I'll go over some of the major developments in some detail. On the setback side, I'm going to talk about the Cummings decision, a decision out of the Supreme Court last term, eliminating the award of emotional distress damages for violations of Title IX, in addition to violations of Title VI, the ACA, and the Rehabilitation Act. So this decision has not gotten as much attention as some of the other decisions at the end of the Supreme Court's term, but certainly has a big impact on gender justice in education. But before I start, I sort of want to pick up where Hunter left off and put both these victories and setbacks into context, and want to start by highlighting the impact of discrimination, particularly violence against and harassment of LGBTQI students who face, as we know, disproportionately high rates of harassment and assault compared to other students. So according to the Human Rights Campaign and a national survey of high school students, gay and bisexual men and women face rates of assault much higher than their straight counterparts. And in a 2015 survey by the Association of American Universities, found that 60% of gay students and 70% of bisexual students reported being sexually harassed on campus. So these are obviously very astounding numbers, and the effect of that discrimination has also been well documented. So according to the CDC, LGBTQI youth face much greater rates of depression, suicide, and substance use. And astoundingly, LGBTQI youth were almost 1.5 times more likely not to go to school within the last 30 days of the survey out of concerns for their safety. And the Trevor Project reported recently that over 40% of LGBTQI youth had seriously considered attempting suicide in the past year, and including more than half for trans and non-binary youth. So I think it's really important to have these impacts in mind when we talk about the expansions and limitations on the scope of protections for the LGBTQI student community, particularly as they relate to harassment and assault. So let's start with a positive. Let's start with the Title IX NPRM. Just as background, as many of you know, under Secretary DeVos during the Trump administration, the department had significantly curtailed many of the protections under Title IX, making it harder to find the school responsible for discrimination against on the basis of sex discrimination. And now the department is seeking to restore some of those protections. So the first major development is, as I mentioned, the explicit definition of sex discrimination to include discrimination on the basis of sexual orientation and gender identity. So this is an interpretation that the Obama administration had adopted in Dear Colleague letters and in guidance that was subsequently rescinded under Trump. But in 2020, the Supreme Court decided Bostock, a decision which held that under Title VII of the Civil Rights Act, which governs non-discrimination obligations in workplaces, holding under Title VII that the Title VII's prohibition of sex discrimination also prohibited discrimination on the basis of sexual orientation and gender identity. And in the first few days in office, President Biden directed all federal agencies to bring their regulations in line with the Bostock decision. And so this NPRM does exactly that. It is, again, an explicit confirmation that, like Title VII, Title IX's prohibition on sex discrimination bars discrimination on the basis of sexual orientation and gender identity. And so obviously what that does is it clarifies that a school has to treat sexual orientation and gender identity discrimination as the same way that it does other sex discrimination. But it also, again, going back to what Hunter was referencing earlier, it also provides a basis to challenge some of the policies and laws that we've seen from states that really target LGBTQI students. So, for example, some of the policies that have been most in the news are bathroom policies. So the NPRM prohibits sex separation when it creates more than just a de minimis harm, and defines excluding trans students because of sex separation as more than just a de minimis harm. So that would apply to bathroom bans, and it would apply to exclusion from sex ed classes and gym classes. Again, we've read a lot about many of these examples. It may also provide a basis to challenge implementation of laws like the Don't Say Gay law in Florida, where these inquiries will be a little bit more fact specific, but if under the law a student is disciplined for talking about a crush on a student of the same sex, whereas a student who talks about having a crush on someone of the opposite sex is not disciplined, that very much may run afoul Title IX under the new regs. Or under the new proposed regs. There are two big questions, though, that the NPRM does not address with respect to sex separation, and that is sex separation in dorms and in sports. And in sports in particular, the department is undertaking another rulemaking that will be forthcoming, and so we'll definitely monitor. We'll definitely monitor that. That will hopefully come within the next few months. I will just mention that in the Trevor Project survey that I referenced earlier, 94% of respondents said that recent national politics had had a negative impact on their mental health. So again, the effect of laws like this and the ability to respond to them is something that is incredibly important. The second component of the NPRM that I want to talk about is the expansion of the definition of sexual harassment. So just as context, as many of you may know, sexual harassment includes both quid pro quo harassment and hostile environment harassment. So quid pro quo harassment is when an agent or employee of the school conditions a benefit on a person's participation in unwelcome sexual conduct. And hostile environment harassment is something that the school can be responsible for only if the harassment reaches above a certain threshold. And that threshold is what the NPRM is changing. So under the DeVos era regulations, the definition of hostile environment was limited to unwelcome conduct that was severe, pervasive, and objectively offensive. So that is a very, very high bar, and certainly a departure from standards under other statutes that prohibit discrimination, like Title VII, like Title VI. And what it did was it created a double standard where sexual harassment under Title IX was evaluated under a much higher standard than racial harassment under Title VI. And so now what the current NPRM is proposing to do is returning to the severe or pervasive standard, which is what we see under Title VII and Title VI, in determining what constitutes a hostile environment, and also emphasizing that this is a very fact-specific inquiry, which takes into account factors like the type and frequency and duration of the conduct, in addition to the party's age. So you can imagine a scenario where something that might not be severe or pervasive for a graduate student may be for a freshman. So these are all factors that have to be taken into account in a determination of whether the threshold for a hostile environment has been met. And the last component I want to talk about is increasing the school's obligation to investigate and respond to harassment. So this was another big obstacle in holding the school responsible for discrimination, was the standard in the DeVos regulations that required deliberate indifference or actual knowledge of discrimination on the part of the school before the school could be found liable. And this, again, set a very, very high bar to liability. So a school could act unreasonably and just ignoring a complaint of discrimination, so taking a head in the sand approach. But that conduct might not rise to the level of deliberate indifference and may have shielded the school from receiving actual knowledge of the discrimination. So under the NPRM, it specifically eliminates the deliberate indifference and actual knowledge standards and says that the school must now take prompt and effective action to end anti-sex discrimination. So this we very much interpret as an affirmative obligation on the part of the school that would require the school to act when it had reason to believe that there was discrimination. So these are just three of the primary developments. They are a couple among many that are important, but these three certainly remove significant barriers in enforcing Title IX against schools. I think that the takeaway here is that the DeVos era regulations did send a very clear message that sex-based discrimination, particularly sexual harassment and assault, were not to be taken seriously and not a priority, and very much hope that the NPRM is a step in the opposite direction and we see some more momentum behind Title IX challenges. So now I'm going to turn, unfortunately, to some of the setbacks. So, we just talked about holding schools responsible under Title IX. And so I want to turn to talking about the Supreme Court decisions in Cummings, which really impacts the remedy of what students can receive after a finding of a violation. So the question before the court in Cummings was whether emotional distress damages could be available for violations of statutes that regulated non-discrimination obligations of federal funding recipients. So that would be Title VI, and then statutes that were sort of modeled after the language of Title VI. So that would be Title IX, the Rehabilitation Act, and the Affordable Care Act. So the Fifth Circuit found that these obligations in these statutes were akin to contractual obligations attached to federal funding. And because they were contractual in nature, no emotional distress damages were available, because usually emotional distress damages are not available for breach of contract. So actually at the Supreme Court, the ACLU and the Law Center jointly submitted an amicus highlighting a couple of important arguments. The first is that courts have in fact found emotional distress damages to be regularly available under these statutes, and also highlighting the importance of non-economic injuries that flow from discrimination. This is something that Congress recognized in passing the Civil Rights Act of 1964, recognizing specifically the dignitary harm that discrimination caused. And for students covered by Title IX in particular, we highlighted that younger students were were very unlikely to have significant economic injuries because it would be difficult to show that they had lost, that they had any pecuniary loss, and that cases involving harassment and assault, which again, unfortunately, is experienced disproportionately by LGBTQI students, are instances where emotional distress damages might be particular, or emotional distress injuries might be particularly acute. So unfortunately, the Supreme Court rejected these arguments and agreed with the Fifth Circuit that as a general matter, the statutes at issue created more contract-like obligations for which emotional distress damages are not available. And so I think, I mean, that there's no way to sugarcoat this. It is a huge loss, and it will have major impact in several ways. So the first is, and most obvious, is that it limits the recovery that students can get for emotional distress. And the second is that it signals the relative importance or really lack of importance of non-pecuniary harms that result from discrimination. So, you know, really a step away from recognizing the dignitary harm that discrimination causes. And the third is that it really alters the incentives for schools that do violate Title IX and Title VI. So, you know, if there are not really economic damages, and there's also no possibility of emotional distress damages, then there may really not be as much of an incentive to comply with these non-discrimination obligations. So I think, you know, trying to end on a more positive note, you know, what can we do in response so that there won't be a complete fix, but we can certainly look to other statutes that cite Title IX. So the first source is state and local civil rights laws. So I'll note that just DC and New York both have human rights laws that prohibit discrimination in education and also allow for non-pecuniary, or what we call compensatory damages. And then also, I think we can consider whether Title VII claims are available. So Title VII governs non-discrimination obligations in the workplace, and under Title VII, compensatory damages are available, although they are subject to statutory caps. But I think, you know, recognizing that a significant proportion of students may also be workers, including participants in work-study programs and graduate students, both the EEOC and the Department of Labor have found both these sets of students to be potentially employees, but the inquiry is a very fact-specific one, and it turns on whether the students' work is primarily for their own educational benefit or rather whether it's for the school. And it may depend on factors like whether there's an employment contract or whether the student is paid, and if so, whether they're paid on a regular basis. But as you may know, this is currently a very hotly litigated topic. You may have heard of it in the context of athletics, the question of whether students are workers as well. And it really may heighten the stakes of these debates. So I think I'll end there, and again, we'll be happy to take more questions in the end. And now we'll turn it over to Dan to address some of the thornier issues in religious exemptions.
Thanks for that. Thanks to the Law Center, first of all, for bringing this event together. And thanks to you, Ming, for that helpful review of some of the protections that are available to LGBTQI+ students. Now, even when the safeguards and protections apply, there are a host of religious exemptions that may be available to those who still want to discriminate, unfortunately. So that's what I'm going to focus on here. Religious exemptions to available protections. When representing LGBTQI+ students, unfortunately, you need to be aware of these exemptions, when they apply, and what you can do about it. Now, before jumping into that, I think it's worth flagging some of the trends in this area, not just in the context of schools, but everywhere. As I'm sure you all know, the current conservative majority on the Supreme Court has been on a mission to expand religious exemptions almost every chance they get, even when it results in discrimination or other harms, even when other important rights are at stake. So in recent years, I'm just focusing on recent years now, the court has sided with a variety of plaintiffs seeking religious exemptions, everything from Hobby Lobby, a craft store claiming a right to deny employees insurance coverage for contraception, Masterpiece Cake Shop, a bakery discriminating against same-sex couples, religious employers discriminating on all sorts of bases when they then claim that the employees are ministers and therefore the employer is entitled to an exception from all employment discrimination laws. Then there's the Fulton case, government contractor discriminating against LGBTQI plus families seeking to become foster parents. And in the context of education, which is today's focus, the court issued 2 decisions just last month that, while they're not exemption cases, they did limit the ability of state and local governments to enforce important protections, in those cases, important church-state protections. So that's the background. It's pretty grim. And now I'll turn to what are the religious exemptions that may be available to those who want to discriminate in the context of education. First, I'll focus on statutory exemptions, and then I'll turn to some constitutional ones. Title IX has an extremely broad religious exemption for educational institutions that are, quote, controlled by a religious organization. And the exemption applies under the statute if the application of the statute itself is inconsistent with the religious tenets of the organization. Now, the recent NPRM that you heard about doesn't really address these exemptions. It doesn't really change much when it comes to the religious exemptions and the broad religious exemption for these religious schools. And keep in mind, this is just for religious schools. This is not for anyone who works at any school. Now, the NPRM could have tinkered around the margins. There are things that could have been made better here that weren't changed. For example, requiring schools to disclose that they're getting an exemption in the first place. So at least students know when a school is claiming an exemption. That didn't happen. Limiting, another thing they could have done is limiting exemptions to specific policies or statutory requirements so that schools would have to explain not only that they want a religious exemption writ large, but they would have to explain the particular rule to which they object. So that would force, if they had done this, which they didn't, that would have forced schools to say publicly, no, we have a religious reason, for example, to allow sexual harassment at the school. Now, no school is going to want to do that. It would have been nice for Department of Education to require that, but that's not the case now. Another thing that was not changed, there's an extremely broad notion of which schools, which religious schools actually qualify for this exemption in the first place. Now, the text of the statute, as I mentioned, speaks of schools that are controlled by a religious organization, but the rules in place now are not really true to that language. So it's enough right now for a school to have a statement of doctrine or of religious practice that members of the school espouse a personal belief in something, or that has a mission that includes or even refers to religious tenets. So it's much broader than controlled by a religious institution. That goes well beyond the provisions of the language of the statute, but there you have it. I think the problem here, though, is the statute itself, which again is just a broad exemption for religious schools. So take one recent example. BYU changed its honor code a few years ago to seemingly become more inclusive, but The school quickly reversed course, and it issued a letter clarifying that, and this is from the letter, quote, same-sex romantic behavior was, quote, not compatible with the principles in the school's honor code. And protests erupted outside of BYU itself and LDS church headquarters. And then there was an investigation open, but the Department of Education dropped the investigation in February. And once the school asserted a religious exemption, the department said, okay, hands off. Now there's a pending lawsuit challenging the statute itself as an Establishment Clause violation. There's the Religious Exemption Accountability Project has filed a class action lawsuit in federal court in Oregon to invalidate Title IX's religious exemption as unconstitutional. And there are dozens of plaintiffs in the case, including students from a wide variety of religious universities and other schools. And the lawsuit essentially argues that the Department of Education is required to protect LGBTQI+ students from discrimination at any school that's federally funded, which is basically all schools, including religious colleges. Now, in theory, there should be a strong argument. There's a notion in Establishment Clause law that when you when a religious accommodation inflicts harm on third parties, that itself is an Establishment Clause violation because it's elevating religion at the expense of others. But I think in this legal climate, it's going to be tough. It's an uphill climb, but we'll see what happens there. Okay, so Title IX is one of the statutes I want to talk about. Ming referred to Title VII. That's another one. First of all, that protects employees against religious discrimination. But there's something about Title VII that could be used actually to further discrimination, or that has at least been invoked to do so, and that's the following. Employees can seek religious accommodations from their employers, and that includes teachers, for example, who want religious accommodations. The employer has to provide that accommodation, sorry for the siren, unless doing so would impose an undue hardship on the employer. What does that mean? It should be, and the law is, that an undue hardship is anything more than a de minimis cost or burden. That should be easy to satisfy. So if a teacher says, I have a Title VII right, I'm going to talk about this a little more, I have a religious right to discriminate against, say, trans students, the employer should be able to come back and say, well, no, I can't grant you whatever religious accommodation you're requesting, because that's going to impose a hardship. What's the hardship? The hardship is on the students or on other employees. But in practice, that has caused some issues, and it has allowed some level of discrimination. Another statutory source of religious exemptions is RFRA, the Religious Freedom Restoration Act. This expands free exercise rights right now against the federal government, although many states have their own analogs. Now, you heard about the decision in the Supreme Court's decision in Bostock, which extended employment discrimination protections under Title VII to sexual orientation and gender identity. But in that same opinion, the court described RFRA as a, quote, super statute, and suggested that it might be an exception to civil rights laws. Unfortunately, some lower courts are already treating it that way. So one example of how RFRA has been invoked in the school setting to further discrimination, there's a pending challenge in the Eighth Circuit by a religiously affiliated college to HUD's directive. Well, this is a directive that interprets the Fair Housing Act to bar discrimination based on sexual orientation and gender identity. The college claims that the directive would interfere with its ability to house students based on their sex assigned at birth, and it would interfere with their ability, they say, to make statements about that policy, which they say violates their religious rights. Those are some of the statutory sources of religious exemptions. There are also constitutional sources of religious exemptions. As I said, the court has expanded these exemptions often on constitutional grounds. There are some very aggressive attempts to claim those rights to discriminate. And a lot of these cases include a grab bag of claims. So I'm talking about constitutional claims right now, but these include constitutional claims, statutory claims. Many of these in the school's context involved claimed rights to misgender students. I'm not going to talk about each case, there are too many of them, but I'll give you some general themes. The law is not settled in this area. There are some good decisions, some bad ones, and everything's pretty much in flux here. So just broad categories. There are at least 5 cases that have been brought by public school teachers who were disciplined for refusing, based on their religious beliefs, to comply with good policies at schools requiring teachers to use pronouns consistent with trans students' gender identities. There are mixed results from these cases, and there's at least one decision from last March from the 6th Circuit, which ruled in favor of a public university professor who claimed that the school violated his rights, his free speech and religious rights, when it disciplined him for refusing to use trans students' pronouns. The court reversed a dismissal from the lower court. The case is since settled, but it's something to worry about there. There are several other of those. Like I said, there are at least 5 of them. I'm not going to run through them all, but Indiana, Virginia has several, Kansas. So there are a number of them out there. Relatedly, there are at least 4 cases that have been brought by students and parents challenging school policies that require faculty, staff, and other guests at school events to use names and pronouns consistent with students' gender identities. And so these are brought by students and parents. So there's a chunk of the cases brought by teachers saying they have a right to misgender, and then there are a bunch of cases brought by students and parents challenging what we would view as good school policies. Again, not going to run through them all, but Wisconsin, New Hampshire, Massachusetts, some of these cases are in state court, some of these cases are in federal court. And there are a lot of other disturbing related cases out there. Just one example, in federal court in Oregon, there are a number of educators who sued after a school placed them on administrative leave for launching a public campaign to exclude trans students from using facilities consistent with their gender identity. And these plaintiffs claim that the school violated their state and federal constitutional rights, including their free exercise rights, their religious rights. Now, I don't want to paint too bleak a picture here. It's not all bad. There was last month, in fact, a New York State court case, somewhat different set of facts, but this involved Yeshiva University. There was a group called Yeshiva University Pride Alliance. They were not being officially recognized by the school, and they sued under state law, saying that they had a right to be recognized by the school, just like any other student group. And a New York State court ruled in favor of the student group, said that the university was not entitled to the religious exemption under the state statute, and that recognizing this student group wouldn't violate the university's free speech or free exercise rights. I mentioned free speech a lot. That's almost always paired with the free exercise claims in these cases. So what do you do when you're faced with a situation where someone is in a school is claiming a religious right to discriminate? Just want to run through a few bits of advice here, and then I'll close out, and then happy to answer questions after that. Number one, in these, and this applies to attorneys, this applies to schools that are trying to do the right thing. If you're advising those schools, be careful to avoid any language that can be construed as anti-religious. The Masterpiece Cake Shop case turned on the supposed anti-religious statements of some of the state officials who were adjudicating the issue. It was a big stretch, but still the Supreme Court, US Supreme Court, laid down a rule that basically said if it smells at all of anti-religion, then strict scrutiny applies, and it's going to be construed as discriminating against religion. Now, that Sixth Circuit case, just one example, about the university professor who wanted to misgender students. The chair of the department had said things like Christians are primarily motivated out of fear, and should be banned from teaching courses regarding that religion. And then also said that in her view, even the presence of religion in higher education is counterproductive. So the court seized on those claims and said, this proves that this is hostile and discriminatory toward the religious teacher. So don't say anything like that. Advise schools not to say anything like that. That's one bit of advice. Another is just to be aware of the existence of other statutory exemptions. So if a school has a good non-discrimination rule, if it has any exemptions that are not religious, and someone wants to sue and say they have a religious right to a similar exemption, they will rely on those non-religious exemptions and again say, you have to give me the same exemption, otherwise you are discriminating against religion. That the Supreme Court, some of those recent cases I talked about, revolve around the existence of other non-religious exemptions. If they're out there, then religious ones are probably going to have to be offered. Now, what you can do in those cases is you can argue, no, the non-religious exemptions actually further the state's interest, whereas religious exemptions might undermine them. This is something that comes up in a totally unrelated context of vaccine challenges to vaccine requirements, but it's something you should be aware of. All right, a third thing, if there is speech that is being challenged, and if a teacher is saying that they have a right to engage in discriminatory or harassing speech, the more you can characterize that speech as official school speech, particularly if it's in the context of a curriculum or in-class lessons, the more you can do that, the better. One of the recent Supreme Court cases, the Kennedy case involving a public school football coach who wanted to pray at the 50-yard line, that's what that case turned on, was, is this his private speech or is it the school speech? So the more you can make it the school speech, the less the teacher will have a right to claim that they can discriminate. And finally, I mentioned Title VII's accommodation requirement. That is something that often you will, if you're an employer, you will often get a question, please accommodate me. I'm compelled to, by my religion, to whatever it is, misgender students or, to discriminate in some other way or to be harassing. Rather than, the school is going to want to say, no, we are not going to accommodate that for a variety of reasons. Title VII requires a back and forth dialogue between employer and employee. So even if the employer, in this case, the school, knows that ultimately it's going to turn down that request because no, this imposes far more than just a mere hardship. I mean, this is going to end up discriminating against our students and creating this horrible environment. Engage in the process of the back and forth. Say, well, actually, that accommodation is not going to work. Is there anything short of what you're requesting that would satisfy you? Engage in that back and forth, because if this goes to court, you're going to want to say, if you're the employer or if you're working with the employer, you're going to want to say, we tried, rather than we just dismissed this out of hand without considering. Those are just a few bits of advice here. Again, happy to talk more if we have time at the end. And with that, I'll turn it over to Liz.
Hi, folks. Thank you all so much for being here, and thank you so much more to the Legal Network for the invitation. I am Liz Pinolini. I use they, them pronouns, and I am a staff attorney with Whitman Walker Health Legal Services in Washington, D.C., and I handle mostly humanitarian immigration work like asylum and manage our name change practice. I mostly work with queer folks, and I am very excited to talk with you all today about about understanding queer communities and working with a trauma-informed and affirming approach. And now I have a slideshow for you all, starting off with my contact info on. Let's jump in. Our agenda for today is going to be, first off, different forms of mistreatment and discrimination against queer folks. And so it's important to actually look at what that bias. So starting off with understanding trans and non-binary people, we are going to jump in with just some basic terminology. A lot of us have heard these terms before, but it's really important to understand them at their most basic because this really does form the foundation for working with queer people. First off, we all know what sexual orientation is. It's the person's emotional, physical, or romantic attraction to other people. It's the people whom you like, the people whom you want to date or partner with. And it's commonly conflated with gender identity, or the two are wrapped up with each other, when the reality is that they are extremely different concepts. Sexual orientation is about your relationship to other people. Gender identity is your relationship to yourself, and it's your own internal sense of whether you feel and identify as male, female, or somewhere else on the gender spectrum. Another core concept is a person's sex or gender assigned at birth, and that is pretty simple and straightforward. It's just a gender marker that is usually slapped on your birth certificate when you pop out, and that leads to expectations of who you are and how you will develop, and gender stereotypes and gender roles, and that extends further into a person's gender expression or presentation. But what that really is how you choose to communicate your own identity through various external factors that we have control over and that we can change to suit our own personalities. But this idea of expression or presentation extends so much further beyond just gender issues. Think about yourselves and your own lives and how your expression or presentation through clothing, hair, mannerisms, etc., your style has changed over the years. Who you are today is not the same person as who you were in high school, for example. And even now as adults, you have a different style or look from when you are going out with friends versus when you're just casually going about your day-to-day life, or when you are in the office working with other people. So your expression and presentation is something that is fluid and is going to change from a day-to-day basis. Some more definitions to kind of focus more so on the trans non-binary side of things is on the starting off, of course, we have the terminology of being a transgender person, a trans man, trans woman, and that is quite simply somebody who recognizes and internally feels like their identity, their gender identity is different from the sex that they were assigned at birth. So again, that gender marker on your identity documents. In contrast, a cisgender person is the term that we use for somebody who knows that their gender identity does align with the sex or gender that they were assigned at birth. And those really boil down to two Latin prefixes of cis, meaning on the same side of, and trans, meaning on the other side of. And historically, that was even used for things like cis-alpine and trans-alpine, for whether or not something was on the same side of the Alps or on the other side during the Roman Empire, because these are Latin roots. One thing to point out is intersex conditions or differences in sexual development. These are occasionally thought of as part of this entire gender sexual orientation concept, but for a lot of people, these are more commonly thought of as just medical conditions and not necessarily inherently part of somebody's overall identity, because what these are is just conditions related to the development of someone's genital function or their secondary sex characteristics. And if you think all the way back to biology courses when you were in high school, maybe, or college, then you probably learned about a few of these, like Klinefelters, for example, when a person's chromosomes do not line up with this typical XY or XX formation. And these are a lot of different things, but it's something to highlight and note as being kind of, for some people, related to these concepts, but by and large, it's a separate medical issue for folks. The last definition on this slide is just a person's gender transition, and that is a whole bucket of different things. And we'll talk more about what a transition can look like for different people, but by and large, it's just the sort of social, medical, and legal processes through which a person actually goes through and changes their gender expression or their identity to be more congruent with their gender identity. And that has a lot of different components, like I said, that we will touch on in a future slide. But it's a very unique process and highly individualized. I myself identify as queer, and oh boy, the journey that I've had since coming out in 2015, it's been a roller coaster and a whirlwind, and there's no one size fits all gender transition for folks. And that's important for recognizing the need to meet people where they are actually at in their life. Taking a moment now to focus more specifically on going beyond the binary meaning just one of two options. You also have non-binary folks, or more terminology that you might hear is like gender fluid or gender non-conforming, gender expansive. And that is ultimately a person whose gender isn't exclusively one or the other. There is a whole spectrum of identities in between just feeling male or female. And I myself identify as non-binary because to me, I don't find that a gender is important to my identity and who I, it looks like, thank you.
Liz, I think you're freezing. Okay.
And now it looks like I disconnected completely. Oh, I am terribly embarrassed about that, and I'm very sorry, folks. Let's see. Trying to reshare the PowerPoint. Are folks able to actually properly see it this time?
Yes.
All right, cool. So sorry to not be able to have all those definitions up on the screen. However, we can absolutely make the PowerPoint available to folks afterwards, so you can go back and review. But not to waste time, moving back on to the show. All these different things that I've talked about, like birth, sex, or gender, a person's identity, their expression, orientation. Here is a really good time to tune back into the slides because here it really does a good job of encapsulating all of the different options that you might think of and really hone in on the idea that it is a huge spectrum of identities. With birth sex, as we touched on, you tend to have male or female, but those differences in sexual development that are not quite one or the other. A person's gender identity, you have the gamut from male to female, but all of those different identities in between. A person's expression from displaying typically masculine or typically feminine characteristics. In between, we all know what androgynous is, and it's ultimately a person's matter of expressing themselves to the world. And lastly, we have sexual orientation, which again is whom you partner with. And if you really just look at the left side and the right side of this slide, you will see what is basically your stereotypical, or what people think is the common configuration of all of these different traits. You have a male gender marker on your birth certificate, you identify as a man, you tend to present yourself in a masculine fashion, and you're attracted to women, and vice versa. But by now, I hope it is the point has been clear that all of this is a huge spectrum. There is no one size fits all when it comes to identities. So, The next thing to focus on beyond the basic terminology is pronouns. They are a critical part of a person's gender identity, and they should never be assumed based on the way the person looks. I say that pronouns are a critical part of identity because between that and a person's chosen name as opposed to their legal name, those really are the two most fundamental points that convey whether or not you're going to be respectful of a person's identity. We heard a lot about people claiming that they have a fundamental right to misgender somebody or to use their legal name, and that's just nonsense. That is straight up discriminatory behavior, and that instantly communicates a clear disrespect of the person. And so these are fundamental parts of a person's identity, and it's always important to just ask if you are not clear about what a person's pronouns are. You may hear from other people the idea that you have preferred pronouns or preferred name, but again, that's just not the case because at the end of the day, they're not preferences, they are choices that we have. That's why I introduced myself as saying, Liz Punolini, I use they, them pronouns. They're not my preference, they are my choice. And that is, again, of course, something that needs to be respected by everybody. One very good way of kind of normalizing the practice of talking about pronouns and asking about them is to just introduce yourself using them, asking other people when you meet them what pronouns to use. And of course, don't be afraid of the they pronoun, a singular they. For a lot of people, it can be a little bit unfamiliar for them, but it is something that is perfectly valid, and there is a solid historical baseline for using they as a singular pronoun. They've been used by historically literary authors such as Jane Austen in Pride and Prejudice back in 1813, but the first usage of the they, singular they pronoun dates were one of the earliest ones, goes all the way back to the 1375 medieval poem William and the Werewolf. There's a section that was translated from the Middle English to modern, reading that each man hurried till they drew near. So there is historical precedent for using it. And if it's something that is difficult and that you found that it's hard to get used to the they as a pronoun, it's really helpful to just kind of practice to yourself saying things to yourself out loud. For example, I met Liz at this panel. They spoke on best practices with working with queer people. They are an attorney at Whitman Walker, etc. Until it gets normalized. It takes getting used to. I had to adjust to it myself. But it is something that's possible and doable and that should absolutely be done. The last pronouns that I have listed on this slide, such as Z's and Zir, we call those neo-pronouns, and it's something that is coming into fashion, particularly with younger generations. And it's another unusual thing, but it's at first glance, but it's something that you can get used to. And it ultimately comes down always to respecting the person's individual identity. We talked briefly about gender transition on an earlier slide, and here is a more expanded idea of what that actually looks like. It always tends to start off with personal discovery and exploration. And again, just like queer folks kind of discover who they are, think about your own lives. Even if you don't identify as queer, think about how you have changed over the years. Your values have changed over the years. Who you think you are and identify as has changed over the years. So it's not just something exclusive to sexual orientation and gender identity. Personal discovery almost always leads into social transition and kind of coming out to the world to live your own authentic life and be the person that you want to be and know that you are. There are also aspects of medical transition, which include not just hormone therapy, which is a very common thing that people are talking about these days, but it includes all kinds of different surgeries that you might have. It's not just one definitive surgery, such as top or bottom surgery, but there are a whole range of different things, such as make tracheal shaves to get rid of an Adam's apple, facial feminization surgery, a liposuction or body sculpting, many different things. There is no one procedure that makes a person trans. and what a person chooses to do or chooses not to do does not define who they are in relation to their gender identity. The last bucket is a person's legal transition, and that tends to be just updating your identity documents, legally changing your name to align with whom you are. But like it says at the bottom, all trans folks and all queer folks are valid regardless of which aspects of transitioning they might choose to engage in. Another note about legal gender and identity documents specifically, people have gender markers on all sorts of different government documents and records, and they're not all going to line up with each other. Some different states or organization or agencies allow for a non-binary gender marker. Others only offer the binary male or female. There are different processes for updating everything. And so there is ultimately the simple point is that there is no one document that defines a person's legal gender. Legal gender is in and of itself a legal construct, but socially not actually something to think about. I don't have that much time left, so I'm going to try to hurry through a few of these slides and skip over and look at very briefly our major takeaways. This has been a little repetitive, but it's really to hone in some important points that a person's identity is what they say that a person's identity is what that person says that it is, regardless of anything else. The terminology, it's important to get that right and really look into that and know what it is and know what not to say. Gender transition is going to be different for everybody, and regardless of anything, a person's identity is valid, and it's important to always use the name and pronouns and honorifics that a person asks you to. So moving along into bias and its consequences, I'm not going to go through all of these different studies and statistics. Like I said, I can make the PowerPoint available for folks to revisit, but in the United States, around 18 million people identify as queer. Of that, about 0.6% identify as transgender. And so there are huge numbers of folks throughout the United States that this information affects. Discrimination, as we've talked about or previously in the panel, it's extraordinarily rampant. There's mistreatment in place of public accommodation, employment, housing issues that result to significant rates of homelessness and low-income poverty situations. Queer folks and trans folks specifically are very typically targeted for sexual assault, with some horrific statistics like almost half of queer folks in a 27,000 person study reported being sexually assaulted at least one point in their lives. And as a result, 40% reported some severe psychological distress in the month before completing the study itself. And a lot of folks have attempted suicide because of this bias. It extends into employment discrimination in a horrible way, with a lot of folks experience being fired or other employment-related discrimination. As I mentioned, there's a lot of discrimination that happens in housing issues, and it also extends into access not just to healthcare, but other social services like our very own legal services. When people feel like they're going to experience discrimination, they are not going to access services that are life-saving, crucial, that they need. Let's see. More with systemic discrimination, more statistics that you can take a look at. Against transgender folks in particular, it is even worse than compared with the general LGBTQ population. They do tend to be the most adversely affected with some really staggering numbers. I'm going to skip through some of these slides to focus more on creating safe spaces real briefly and how we can look at actually creating inclusive environments. First off, always use a person's chosen name, even if it hasn't been legally changed, and use the correct pronouns. Be mindful of the way that you are communicating your own potential internal biases with verbal or body language, and always respect a person's privacy and dignity. It's important to know that you should never ask about pre-transition photos or names Don't ask about a person's genitals or other aspects of medical transition. Who wants to talk about those things? Who would even think to ask another person about those things? It is wildly inappropriate, and it stands to say, or really it shouldn't need to be said, that you should not be talking about these things. You shouldn't imply that they're being deceptive or unreal because they're using a different name than what might be their legal name. You should never disclose that they're trans without permission. And when misgendering happens, when mistakes happen, it's okay. Those are going to happen from time to time. It's important to just correct yourself. Don't dwell on a lengthy apology, but own up to your mistake and make sure that you're also always correcting your coworkers or other people when you hear misgendering or other discrimination happening. With discrimination and what it can look like specifically, this is based off of the DC Human Rights Act. And here are some very clear examples that we've touched on in earlier parts of the panel. So that refusing to use someone's chosen name or pronouns, or even accidentally not using them repeatedly without actually correcting the behavior, that's just straight up discrimination. Not allowing people to access gender-specific facilities consistent with their gender identity or expression, asking personal or invasive questions about these topics. It seems pretty straightforward, but it's shocking to think and look at the number of employers that don't always realize that this is what discrimination looks like and it needs to be corrected. The biggest one is about permitting staff to or other coworkers to use offensive language or otherwise create hostile work environments. And that's something that really needs to be nipped in the bud wherever you actually see that. To touch briefly on judicial ethics and other court issues, a lot of those concepts carry over because first off, judges are leaders. They command their courtroom, and they not only should not be manifesting any bias or prejudice, but they have a judicially ethical obligation to not permit court staff, officials, or anyone else subject to the judge's discretion and control to do so or engage in those practices. And judges should be requiring lawyers to proceed in a respectful way that does not manifest any bias or prejudice or engage in any sort of harassment. Again, and if you see these sort of behaviors happening in courts, it's important to call that out or reach out to the judiciary and talk about possibly doing sort of a queer competency or sensitivity training to make sure that they are knowledgeable about these things and how they affect folks. So final thoughts to wrap this up. I apologize for going over time a little bit, but again, it's a little repetitive, but it always stands to, it's important to really reinforce these ideas that you never assume a person's identity or who they are. It's always important to meet a person where they're at and understand and ask what their names, pronouns are that they use. Treat people just as they are and meet them where they're at and understand what they need, ask them what they need, and always maintain the most respectful approach that you can. And that's a pretty easy roadmap to actually working with people in a respectful way that doesn't invalidate their identity. Now, we have a whole host of affirming services here, Women Walker. I won't get into it. But again, if folks want to talk more after this is over, my contact information is on the first slide, and I'm happy to talk more if you would like. So that is what I have for my portion of the panel. Sorry to try to rush through it a little bit, but thank you so much.
Thank you to Liz, and thank you to Ming and Daniel for your guys's amazing, very in-depth presentations. I feel like I at least learned a lot about some very powerful tools that we have in our box as legal advocates to better support LGBTQI people. So thank you guys so much for all the information and thoughts that you've shared on how we can do that. I know that we are